Are you at risk of being banned from the United States for 3 or even 10 years because you overstayed your non-immigrant visa? In this video, I'll be providing you with information to help prevent you from being subject to the 3 or 10-year bans. Hi, I'm Jason Calderon from Calderon Law Office PC. I'm an immigration attorney here in New York City, and my office is located in Lower Manhattan. My goal for this channel is to provide you with the latest immigration updates, as well as useful information to help you achieve your immigration goals. If that sounds interesting to you, please click the like button, subscribe, and turn on your bell notifications, because I have a lot of content to share with you all. Let's get started. So what happens when you overstay a non-immigrant visa? Well, first, let's distinguish the difference between an immigrant visa and a non-immigrant visa. The difference has to do with the purpose of your travel to the United States. Immigrant visas are issued to foreign nationals who intend to come to the United States to live permanently, while non-immigrant visas are issued to foreign nationals who intend to come to the U.S. for a short time for a specific reason, whether it's for medical treatment, tourism, or to study. These are actually just a few examples. There are more than 20 non-immigrant visa categories. So, how long is a foreign national permitted to remain in the United States with a non-immigrant visa? Well, it depends on the type of visa. But the answer actually can't be found on the visa itself. You see, a non-immigrant visa can be valid for several years, but it doesn't govern the amount of authorized time in the United States. Instead, it allows you to enter the United States during that specific time frame. You have to look for what's called the Form I-94 Arrival Departure Record. This will give you a date that says admit until, and this is the last day you're allowed to remain in the country. Now, let's talk about the 3 and 10-year bars to re-entry. Your period of unlawful presence begins the day your status expires. But the following bars are only triggered once the foreign national leaves the U.S. If a foreign national remains in the United States for 180 days after their status expires, but less than 1 year, if that foreign national leaves the U.S., they're banned from returning to the U.S. for 3 years. If a foreign national remains in the United States for 1 year or more after their status expires and then leaves the U.S., they're banned from returning for 10 years. Your visa will automatically be canceled or revoked. These are very serious consequences to overstaying your non-immigrant visa. So what can you do to avoid triggering one of these bans? Well, there's a provision in U.S. immigration law which forgives immediate relatives of U.S. citizens from accumulating unlawful presence after overstaying their non-immigrant visas and allows them to adjust their status to permanent resident here in the United States. So who's considered an immediate relative? What is adjustment of status and who qualifies for it? Let's break it down. Let's start with the immediate relative category. This includes the spouse, the parents, or the unmarried minor children of U.S. citizens. Now let's discuss adjustment of status. This is the process a foreign national would use to change their status to that of lawful permanent resident or green card holder from within the United States. So you don't have to leave the U.S. and you don't need a complicated waiver. Generally speaking, adjustment of status is available to foreign nationals who have a lawful entry into the U.S., are admissible, and have a visa immediately available to them. What means being admissible? Well, there's a long list of reasons that make you inadmissible. One example is health-related grounds. There can also be criminal-related grounds, but also unlawful entry and other immigration violations. I always recommend discussing with an experienced immigration attorney if you have any doubts or feel that you have any issues that might make you inadmissible. Now, there's a couple of things I want you to take note of that are very important. Number one, you have to have the right intent when you come to the United States with a non-immigrant visa, such as a tourist visa. For instance, it's one thing to come to the U.S. to, let's say, visit family and then fall in love with someone, and then you eventually overstay because you see yourself marrying them. It's totally different to come to the U.S. with the intention to just remain here the whole time. If discovered down the line when you're doing an adjustment of status application, this can be deemed a misrepresentation, and this could make you inadmissible, like we discussed earlier. If you have any issues like this, I recommend speaking to an experienced immigration attorney before filing your paperwork. It's also important to note that although an immediate relative of a U.S. citizen is eligible to adjust their status, it doesn't mean they're not vulnerable to being detained and being placed in removal proceedings. So what does this mean? If you're someone who's eligible for adjustment of status, don't hesitate. File your applications as soon as possible. Stay tuned for my upcoming series on adjustment of status. If you have any questions on adjustment of status, overstaying a non-immigrant visa, or any other family-based immigration questions, please feel free to call or email me. I'd love to schedule a consultation, whether in person or virtually. That's all for today. Please remember to like, subscribe, and turn on your bell notifications to be alerted when I have new content. Until next time.